This is Central Queensland University, week number 6 in the Introduction to Law course in the summer semester of 2011-2014. This week we'll be talking about ethics and justice, and the commentary for this week's tutorial is from the new lawyer, James Field, as usual, chapters 12 and 13. Chapter 12 dealing with the topic of being committed to justice, and Chapter 13, the topic of being ethical. Now, I propose to work my way through the book and make some comments as we go. So, if I could have you open up at page 406 of your text. As usual, please feel free to stop me at any stage to ask any questions as we go. Otherwise, I'll provide a commentary. All right. Now, being committed to justice. In the practice of law, we are essentially, for the most part, in business, and we therefore need to trade, if I can use that term, at a profit. I'm talking particularly there about those practitioners who go into private practice in a law firm. However, many of the same principles apply for those lawyers who are perhaps involved in a community legal centre or at legal aid, in that there is still an expectation that you will get through a certain amount of work and essentially be profitable, that your time is used usefully. So sometimes what you need to do is in conflict with what you want to do. And I say that in the context of being committed to justice. There are many, many instances, practically on a daily basis, where lawyers are invited to take on a case because it would likely achieve or hopefully achieve a just outcome. But the problem is, how do you do that? How do you take on those tasks and still run at a profit or complete your timesheet as required or fulfil your overall commitment to the legal aid office or the community legal centre if you happen to be employed by them? So it's always difficult to know how to juggle that. Can I say that in my practice, which is primarily in criminal law, I have difficulties where clients are subject to problems associated with mental health. And many of the defendants that appear in the magistrate's court are people that are having problems with substance abuse, alcohol or drugs typically, but also mental health issues. And that creates some difficulty in trying to achieve a just outcome for people that might be looking at a conviction for a criminal offence in circumstances where you believe that they either have a defence or at least strong mitigation based on mental health issues. The same sorts of issues can sometimes appear in relation to my other job, which is hearing cases for the Queensland Civil and Administrative Tribunal, where mental health issues are often the subject of guardianship proceedings. And it may be that in those circumstances, people are unable to make decisions or sign documents for themselves. So we have the same issues surrounding themselves in an application for guardianship or administration for an adult in the QCAT jurisdiction. Any questions so far on what I've said? Thank you. I'll leave you to read for yourself the commentaries in relation to the theories of justice and the types of justice, distributive justice, desert theory, utilitarianism, etc. But I do want to make some special comments in relation to page 410, procedural justice. So procedural justice is achieved if a person receives a fair hearing or trial. And this is particularly of interest to me in the criminal law jurisdiction, but it does have wide-ranging application in general litigation in a legal practice. So, how does one achieve a fair hearing or trial? Can I make a general observation, and that is that in the time that I've been practicing, since the early 1980s, things have changed to a degree, and largely I'll say the changes are reflected are reflective of increasing pressure on the court system because of additional numbers and lack of funding to cater for what we would necessarily hope to achieve. Let me explain a bit more in a bit more detail. In the Magistrates Court jurisdiction, at the moment, we are dealing with many more cases than was the situation a few years ago prior to the Moynihan changes. The Moynihan changes had the effect of downgrading, in essence, charges in the sense that they were previously dealt with in the district court and they're now dealt with in the magistrates court. An example, just off the top of my head, is a charge of going armed as to cause fear. That was a charge which 3 years ago had to go to the district court, where it would be dealt with by a district court judge who would supervise a jury in contested matters. Now, that's a matter that must be dealt with in the magistrates court. The difference from a procedural justice perspective is this. Legal aid funding would be available as of right for anyone who financially qualified, which is most of the people in the criminal law jurisdiction, if the matter was dealt with in the district court. In other words, for someone charged with going armed as to cause fear in the year 2009, the matter would be dealt with in the district court, and if they wish to contest the matter, those people eligible for legal aid would have the benefit of a government-funded solicitor and a government-funded barrister. Now, in 2013, a person charged with exactly the same charge, going armed as to cause fear, must be dealt with in the magistrates court. And if they wish to deal with the matter by way of contesting it on a plea of not guilty, in all likelihood, in reality, they're not able to access any legal representation, whether it's a solicitor or a barrister, through legal aid, simply because funding is not available as of right in the magistrates court, and funding in the magistrates court is subject typically to various preconditions and checklists, which in real terms makes it very difficult for a client to obtain legal representation. So when we talk about procedural fairness or procedural justice, a person having a right to a fair hearing or trial, one of the things that you might consider is whether the people in those circumstances have the right to legal representation. Is that something which people should expect in order to achieve a fair hearing or trial? Some other things of note: there is the right to cross-examine the evidence presented against them in a trial. Again, if someone can't afford a lawyer and legal aid isn't made available, then there are some obvious difficulties in exercising that right in a practical sense. But I will just raise one technical issue when it comes to the question of cross-examining witnesses for the other side. If you are on the defence, if you're acting in defence, and you have an opportunity to cross-examine prosecution witnesses, be aware of a thing called the rule in Brown and Dunn. Now, that's a case. Brown is B-R-O-W-N-E, against is V, Dunn, D-U-N-N. The rule in Brown and Dunn is simply this, that if you're cross-examining a witness, to a degree, you need to put your client's case to that witness so that they can comment. Let me try to think of an example on the run. A police officer says, I saw the defendant in the proceedings drive away in a motor vehicle. If you intend to call your client as into the witness box to give evidence, which you don't have to do, but if you choose to do that, and you know that your client is going to say that he was on that day riding a motorbike and was not driving a car, and the rule in Brown and Dunn would require you to put to the police officer concerned the proposition that in fact your client was on a motorcycle or a motorbike and not in a motor vehicle. The rule is designed for fairness, and it means that the witness in the witness box is given an opportunity to comment on what you're going to suggest when it's your turn to lead evidence. Now, have I confused everyone, or is there anyone who has any questions on Brown and Dunn?
I've got a question.
Yes.
What jurisdiction is the Brown and Dunn rule in? Is that a Queensland jurisdiction?
No, look, you'd think I'd come prepared with the citation. It's a very old case,
That's all right.
but it's easily found. If you Google Brown and Dunn, or you look in some research books, you'll find it very quickly.
Okay, thank you.
Thank you. Any other questions? Okay. So, coming back to procedural justice, person receiving a fair hearing or trial, the right of a legal matter to be heard before a jury. Well, I've alluded to this already. Because of changes to the way in which criminal law is administered in Queensland, in many instances where matters must have been heard before a jury or could have been heard by a jury on the defence election, post-Moynihan changes, that can no longer happen. So when we talk in terms of a right for a person to have a matter heard before a jury that is subject to some very considerable legislative constraints which preclude that from happening. Can I just say also, the bottom one on page 410, procedural justice achieved by placing the burden of proof upon the party bringing the action. Let me just pause on that and reflect on what it means. If you are required to attend court to defend a matter, you are, from the perspective of procedural justice, entitled to expect that the burden of proving the case is on the person who brought you there. So in the context of police, if a charge is levelled against you and you do attend court as a defendant, you can, if you wish, say absolutely nothing and offer no evidence and call no evidence, but simply attend and contest the matter on the basis that you are challenging whether the police are able to establish the charge and make out the charge, because it's up to the police to prove the charge. Likewise, if you're defending an action in contract in civil law and you appear as the defendant in those proceedings, it's incumbent upon the plaintiff, the applicant, the person bringing the application, to prove the case. So the burden of proof is also known as the onus of proof. And I'll just say that the standard of proof, the level to which it must be proved, differs between criminal law jurisdiction and civil jurisdiction. In a criminal law trial, the prosecution has the burden of proof or the onus of proof. It's up to them to prove the case, but to what degree? In criminal law proceedings, prosecution must prove the case beyond reasonable doubt, whereas in a civil case, the applicant, the plaintiff, the person bringing the action has the burden of proof, but only on the balance of probabilities, what's more or less likely. So any questions there about those concepts of the burden of proof and the standard of proof?
Yeah.
Okay.
Not so much on that, John, but in Queensland, are there judge-only trials now? I know there are in New South Wales, but are there in Queensland?
Yes, I haven't been involved in one yet, but yes, there are. It is possible to have a judge-only trial.
And is that at the request of the defence?
To be honest, I'd need to research that a bit more. I haven't had cause to consider the matter, but I should have at this stage. I think, generally speaking, from what I know, it would generally be on the request of defence, possibly solely at the request of defence, in circumstances where the existence of a jury to determine the matter may be impossible to achieve, justice may be impossible to achieve because the jury will have a preconditioned bias. I'm thinking of very high-profile cases where it would be practically impossible to find someone who knows nothing about the case or doesn't have a preconceived notion. Or possibly in technical matters where the jury would find it very difficult to follow the evidence of a very technical nature. So off the top of my head, I think you're right. I think it would be the defence to raise the issue and make the application, and I think they would be the issues, the likely issues, for a judge to consider in determining that request. Thank you, John. Any other questions at this stage? All right.
I have a question concerning the evidence, for example, that we need to give a heads up for the other witness of what our witness is going to testify for.
The rule in Brown and Dunn.
The rule in Brown and Dunn. Do we give a copy of the testimony of our witness to the prosecution? If we are the defense, we give it to the prosecution. Is it the same rule that exists that we shouldn't present anything to court that the prosecution doesn't know about, so that they can have time to prepare before?
To answer your question, very rarely would I ever, in defence, give a copy of my evidence to prosecution. In other words, it works one way, but it doesn't work the other way. There is an important exception to that, and that is for alibi evidence. So if your defence is, I wasn't there, I was on holidays in the Bahamas at the time, then you are required to give notice to prosecution within 14 days of the committal in relation to district and Supreme Court matters, so that prosecution have an opportunity to check that defence out. But that would generally be the only time that you provide a statement to the other side. And can I just say that if you're not going to call evidence, you're not going to put your defendant in the witness box, and you're not going to call anyone else to give evidence on behalf of defence, then really the rule in Brown and Dunn is of no application, because you're not putting forward evidence which you should give prosecution a chance to comment upon in the witness box.
If I'm the prosecution, I should follow the rule of Dunn, the rule of Brown and Dunn always.
Well, the rule in Brown and Dunn is really a rule that applies to defence only, because the defence goes second, and the defence will be after the prosecution has closed its case. So if, to take that example, we had someone coming in and giving evidence, look, I was on a motorbike, not in a car, the prosecution might want to say, well, can we call that officer back again, so that the officer has a chance to comment on that evidence. So to try and avoid that sort of situation of constantly calling and recalling witnesses, the rule in Brown and Dunn requires you to put that to the witness in the first instance. Thank you, Carla. All right. If I could move forward to page 412, just retributive justice is all about retribution, and I guess it all started with an eye for an eye. And there's a distinction here between restoration against retribution. So seeking retribution is seeking an appropriate response as perceived by the person seeking that response to criminal activity, whereas restoration is more about restoring or healing the situation and reintegrating the offender into the community. Keep that in mind if you're involved in a debate or an argument about what is an appropriate form of punishment for an offender. So, for example, if one is calling for mandatory imprisonment for life, let's say for possession of a certain drug, you need to ask yourself the question, why am I advancing that as an appropriate remedy in justice by way of punishment? Is it because I seek retribution for that offence, or am I seeking restoration of justice? And restorative justice is more about dealing with rehabilitation rather than punishment for the sake of punishment. Now, page 413, access to justice. I've made comment about legal aid funding and some difficulties. I've also made comment about lawyer-free jurisdictions. Many tribunals will not allow lawyers to appear as advocates as of right, and they need to seek leave to appear in some circumstances. Can I move forward, unless you have any questions, to page 418, which deals with the matter of cost. Now, this is all under the general heading of being committed to justice. I've talked about how cost factors can limit many people access to legal services, particularly in light of changes to legal aid and the way in which criminal law jurisdictions are run. But when it comes to costs in a civil jurisdiction in particular, parties need to be aware of the risks of running to trial to advance their case for fear that they may have a costs order made against them. Now, when we talk about costs, COSTS, in a legal sense, it's quite a particular term, and it really means the cost of litigation. But there are two types of costs that we refer to. The first is the amount which a client pays to a lawyer to litigate a matter is what we refer to as a solicitor and own client costs, as opposed to a thing called party and party costs. Now, here's the difference in real terms. If I was to take on a case and sue a particular person for breach of contract alleged, and if I engaged a lawyer, solicitor and barrister, by the time I've completed my 3-day hearing in the Supreme Court in relation to this alleged breach of contract, I may have spent with my legal team $100,000. If I happen to lose the case, the other party, which was dragged along to court, and also, let's say, incurred $100,000 of expenses, is entitled to stand up in front of the court and say, given that the plaintiff did not make out his case, and we were the victors in the decision, we are surely entitled to have some of our costs, if not all of our costs, paid for by the person who dragged us along in the first place. The court generally will follow the rule that costs follow the event, technical term, but simply meaning this. If you lose, you can expect to have to pay some or all of the other side costs. The other side may say, we would like a costs order, and we would like that costs order made on a solicitor and own client basis. What that means in essence is they want the unsuccessful party, let's say me, to pay all of their costs, $100,000. Alternatively, they may ask for, or the court may award, costs on a party and party basis. And what that really means is in accordance with a scale of costs, not necessarily what you've actually paid out, but what you might be at law entitled to. The best way I can describe this is if you go to a doctor, you may pay nothing in that everything may be charged through Medicare, or you may pay a gap. And in that scenario, if you're paying a gap, the amount that is paid to the doctor is like the solicitor and own client costs. It's everything that's paid. Whereas if you're paying nothing, it's really the award, which is like the party and party costs. So the party and party costs are, if you like, subject to a scale up to a certain amount, but they're generally well below what is the solicitor and own client cost. So in that scenario that I've said, the solicitor and own client cost might be $100,000, but the party and party costs might be, say, $60,000. So even if you win after a 3-day hearing, and you get an award for costs on a party and party owned basis, you still have to pay the $40,000 gap between what is awarded on a party and party basis and what you've actually spent, which is a solicitor and own client basis. Any questions about that? I've tried not to confuse you. Yes. Yes, Carla?
So basically, when we read a case where at the end, for example, we see the order of the court, it says that the defendant will bear the burden of all the costs of the trial. So this is what will pay the costs of the cost of the whole trial, even for the other party.
Yes. Now, it was breaking up there a bit. I'm not sure if others had difficulty hearing that question. But yes, you're right. If at the end of the hearing you see that costs are awarded to the successful party, generally speaking, that is party and party costs, which is, if you like, that lower amount, and the successful party will still be unable to claim that additional amount on top, so the $40,000. So even if you win, you still lose in real terms.
So how does the court decide who to pay, which one pays?
Sure. Look, there are 3 basic rules when it comes to costs. The first is there is no order as to costs. That's a rule which we find typically in, say, the family law jurisdiction, often in criminal law cases, often in cases such as domestic violence, and often in small claims type cases. So that's no order as to costs. The second is solicitor and own client costs, or we often call that indemnity costs, meaning whatever it costs you, that's what you'll be entitled to get from the other side. And the third, and the most common, is an award of costs on a party and party basis. And that's the most common. Does that answer your question?
Yes.
Sometimes the whole argument about costs occurs after the trial, and in some instances it might be that on the way through there are arguments. One party might win, one party may lose. In those circumstances, the argument is eventually determined at the end of the trial, and what we say on the way through is that costs are reserved. Does that make sense? So
yes.
If, for example, there's an application and there's a dispute on an interim basis, the judge or magistrate may make a ruling at that stage, but may say, all right, I rule in favour of X or Y, that costs to be reserved in the cause, which means that we'll argue about the costs when we deal with the whole matter. Okay.
John, can I just ask how party is spelled? Is it P-A-R-T-Y or P-A-R-T-E?
P-A-R-T-Y.
Right. Yep.
Thank you. Any other questions there? Jackie, will you ask a question?
No, I'm fine, John.
Okay,
Thanks.
that's fine. You all right, Rachel?
Yes.
Okay, good. All right, just moving forward, some comments on 421, community legal centres, valuable way for free legal advice to be members of the public. And as I mentioned, together with Magistrate Guttridge, as he is now, I set up the Community Legal Centre in Hervey Bay, which is gone on to much bigger and better things, I must say. They're doing a wonderful job. On page 423, we have the heading of conditional costs agreements. A cost agreement is an agreement between the lawyer and the client, and it's a requirement to have a costs agreement. Generally speaking, if the legal costs are likely to be more than $1,500 in Queensland, a conditional cost agreement is really a spec agreement or speculative agreement, essentially no win, no fee agreement. Now, on page 426, there's a reference to the case of Dietrich, High Court decision in 1992, where the court decided that there is no common law right for legal representation to be provided in all cases. So in that instance, there was an argument saying that I do not have access to a lawyer, therefore that's in breach of my common law rights to have legal representation. And the court, probably very sensibly from a cost perspective, said no, that's not the case. On 427, we have some commentary in relation to alternate dispute resolution. This is an area of practice very close to my heart because I'm a great advocate of ADR. When I first started practicing, alternate dispute resolution was pretty much unheard of. It's now very much in the mainstream, and it's used in most jurisdictions, whether we're talking family law or civil disputes, guardianship, not so much guardianship matters, but tribunal matters generally. Alternate dispute resolution is something I would urge you to become familiar with. Some different types that are mentioned there. Negotiation is really an informal way of trying to resolve the dispute in an alternate manner. Mediation is a more formal structured program. Conciliation is like mediation, used in certain circumstances such as industrial relations, and arbitration is similar to going to court. In the Queensland Civil and Administrative Tribunal, we have a thing called a compulsory conference. We call it, shorthand is COCOs. Compulsory conferences can be best described as mediation with muscle, in that the conference, the convener, has the power to make the orders and directions at the end of the mediation. Can I just say that's a very special type of hearing that we have in the tribunal. It's called a hybrid hearing. To my knowledge, it's not used in any other jurisdictions than QCAT, and I don't believe it's yet been used interstate, but it's a creature of creation through QCAT. What it means is this: in some type of hearings, for example, a hearing involving a neighbourhood dispute where a tree destruction order is sought, or a tribunal hearing where there's a review of a decision to destroy a dangerous dog, QCAT has a hybrid hearing policy where we hear the evidence fully, we make a decision, we write that decision, we then seal that written decision in an envelope, and then say to the parties, look, let's see, now that you've heard all the evidence, now that you know that I've made a decision, it's in this envelope, why don't we sit down and we'll talk it through just one more time to see if you can resolve it rather than have this decision imposed upon you. So it is a hearing of the matter, but it's a hybrid hearing in that we have a mediation into it. And it's a wonderful procedure, and I think it's one that will become more popular as we go on. So any questions about ADR, compulsory conferences, hybrid hearings? I know. Thank you. We go to page 430, immigration detention. If we're talking in terms of being committed to justice, this is a very topical area. It's one that I'd encourage you to continue to read. form some opinions, be prepared to engage in debates. If you haven't seen the excellent program which aired on either SBS or ABC called Go Back to Where You Came From, a short series, well worth looking at, and it chronicled a situation where a number of people in the community were enlisted to participate in the program, where they essentially went back to where the refugees came from in the first place and experienced what the refugees experienced, but in reverse. And it was a wonderful show. And hello, Andrew. Nice to have you on board. Now, if I could move through in the textbook to the chapter 13, being ethical, and let's see if I can move fairly quickly through this. I've got lots and lots of highlighting and notes, but I'm just trying to select the more important of those for you to consider. No questions about ethics so far? Well, what I might do is actually refer you to the Australian Solicitors Conduct Rules as being important, and bring you to page 460, if I could have you go to that page. Now, on that page, we have some comments made in relation to your ethical duties when you are an advocate in the court, and in particular, a notation, quite correct, with 3.1, that your duty in court and the administration of justice is paramount and prevails to the extent of inconsistency in any other duty. What that means is that you are, as an advocate, as a lawyer, an officer of the court, and your main duty is to the court. So you've got to be careful not to deceive or knowingly or recklessly mislead the court, which is an allied rule, which is 19.1. Now, a lot of people say, well, how can you therefore act on behalf of someone who you know is guilty and still go to trial and sit there while they plead not guilty? Aren't you misleading the court? I don't think so. And the reason for that is this. If we go back to a principle that we discussed earlier tonight, and that is to do with the burden of proof and the standard of proof, as we said at the start, it's up to the prosecution in a criminal or trial to bring the charge, and having brought the charge, it's up to prosecution to prove that the defendant is guilty beyond reasonable doubt. It's up to them to prove. What that means is that defence is perfectly entitled to sit there and say nothing, be mute. Now, you might know that your client is guilty, or you might reasonably suspect that your client is guilty, but you can still sit there and you can argue the case on a not guilty plea, because it's up to the police, the prosecution, to prove that your client is guilty. And I know it's a fine line, but here's where you've got to be very careful. In those circumstances, you can't say anything which might be regarded as or actually misleading the court. So if, for example, your client wanted you to stand up and make a statement, look, I have no criminal history, and do that because the prosecution haven't presented a criminal history, you may be misleading the court. You can stand up and argue for your client, even though you know that your client has a criminal history, because you're not misleading the court if you don't make the positive statement, my client has no criminal history. So you see the fine line between not challenging what has been said by police as opposed to making a positive statement which you know to be wrong.
What if it's a murder case and somewhere where along the line, while we're deliberating with our client, he confessed to us that he's guilty and he has actually committed the crime, but he wants us to advocate for him anyway.
Yes.
What choices do we have there?
Well, if the client wants to go to trial, one option is to withdraw and have another lawyer come in. If that's not feasible, then, as I mentioned, it's still up to the prosecution to prove the case. So, if the prosecution simply don't have enough evidence, then you can assist the client by following through on that process, but you can't ask any questions which you know to be inconsistent with the truth. So, if, and it's hard for me to give an example on the spot, but you've just got to be careful not to be misleading the court or putting forward propositions that you know are just simply not true.
I think what I'm asking is, what if he confesses to us that he has actually committed the murder, and he says, but I want you to... do we have the choice to actually withdraw from the case on the basis of, I don't know, ethical issues or...
I believe you can withdraw from the case if you want. But let's just say that let's say you suspect that your client is in fact guilty, and your client says, look, I want you to run the case on the basis that I was not there, I was in Sydney, and you know that's not true, then you can't run that case. You can't advance that argument on behalf of the client. But you are entitled to see if the Crown, if the prosecution, are able to make up their case in full, beyond reasonable doubt. Now, the Crown might present their case, but it might be on the basis that your client is probably guilty. Well, that's not good enough. They have to prove that your client is guilty beyond reasonable doubt. And that's where you can defend the client in those circumstances, even though you know or suspect that the client is guilty, provided, of course, that you don't put something forward which you know to be untrue.
John, if the client actually admits to you that he is guilty, you can't in all conscience stand up and defend him, can you?
Well, I think you can, but only in very limited circumstances where the client is simply asking you to go to proof. I think the better course of action is to withdraw and have someone else come in and act for that client. But I think technically you could carry through on trial, but it's very limited, and it's almost like going into a fight with one arm firmly wrapped taped behind your back. So you probably couldn't do a very good job anyway.
But in this situation, and you did withdraw, would you be able to say to the lawyer who was taking the case, this client has admitted to me that he is guilty?
No, you shouldn't do that. The privilege is with the client, the lawyer and own client privilege, and you receive that communication in privileged circumstances, so your duty bound not to say anything. So you wouldn't say that to the other lawyer, no.
What would be the reason that we give for the judge for us withdrawing? If we cannot actually say that we're withdrawing because we admitted to the crime and we don't want to go through with the trial, what would be the other reason that we can give the judge?
Yes. I think you would simply say to the judge that you find yourself ethically conflicted and unable to proceed further. The judge is unlikely to push it harder any further than that. They'll understand.
Okay. Thank you.
Sometimes there are difficulties because the trial might be due to start on that day and you find yourself in that situation. And the judge may say, look, we're proceeding anyway, and you may find yourself stuck in it, in the trial. But as I said, in those circumstances, you're probably going into a fight with one arm behind your back. All right. Can I just make a few comments about page 467? And the concept of ethics of care over other approaches. The argument being advanced by Parker and Evans there is that when you're involved in legal practice, you have to take a holistic view of your clients and their problems, and you need to be prepared to empathise with your client's situation, and importantly consider a non-adversarial way to resolve the dispute. So sometimes it's best to consider how do you avoid going to court rather than trying to accelerate the process and getting into court as quickly as you can. At the end of the day, even though you may have a case where you're likely to win, it may not be in your client's best interest to go to court. To go back to an example we've talked about tonight, it might be that if your client succeeds after a 3-day trial, the client has to pay you $100,000. And it may be that after that 3-day trial, your client receives the benefit of a costs order so that you receive $60,000 from the other side. It still costs your client $40,000, notwithstanding. And in addition to that, your client has distress and anxiety. At worst case scenario, your client may get a costs order for $60,000 from the other side, only to find that the other side declares bankruptcy, so that you in fact receive nothing from that $60,000 at all. You may, from the outset, have tried to encourage your client to resolve the matter by doing something other than go to court, and that's what brings us to that whole concept of alternative dispute resolution and the different avenues that may be available to the client to consider as an alternative to going to court. And that's what I mean by taking a holistic view and not just simply adopting a mindset where you must go to court and this is the only way to solve things. Can I say that was pretty much the way us in the profession dealt with things when I started in the early 80s. We would simply take on a course and we'd a case and we'd go to court. And it was pretty much the only time that people would consider resolving the matter was on the doorstep of the hearing after the legal costs had been incurred. Right.
Are the
Yes, John?
the findings in an alternative dispute resolution legally binding on the parties?
They can be, and very often they are. Technically they're not, but they can be in different scenarios. Certainly my preference is to have lawyers involved in the process of ADR, and the lawyers then can make a legally binding agreement. In many scenarios, the agreement can result in a consent order made by the tribunal. So if, for example, there is a tribunal compulsory conference, then it is open for the tribunal member to make an order, perhaps by consent of the parties following that hearing. Thank you, John. Any other questions? All right, to wrap up, I'm just going to draw your attention to a document which was reproduced on the website with the consent of Dean Morzoni, QC. I've been liaising with the QC, and he's allowed us to use this document, which I think is excellent. I'm just going to go through and mention a couple of things. The first is, before entering, be prepared for your court appearance, and take some time to plan how you're going to deal with the court action. Be punctual and arrive on time. Be ready. Dress with dignity and be polite. Look, upon reflection, there's so much in this one, I'm going to hold it over until next week's session. But I would encourage you in the meantime, as some homework, to read that document if you haven't already. And it's called Etiquette, 50 Tips on How to Behave in and for the courtroom. So we might hold that one over till next week, because we're running out of time and I don't know. So, any questions before we consider wrapping up?
Just one point, John, about Christmas. I noticed on the CQU calendar that the whole university shuts down from 24 December to 2nd of January, and it says that week 8 will recommence the 2nd of January. So basically there's a bit of a hiatus then over the Christmas period.
Okay. I must confess I hadn't considered that, but that makes sense. So I think Christmas Day is a Wednesday.
Yes, yes.
I haven't thought about whether we'll meet on Christmas Eve. I should think that's probably a tough ask for everyone.
Sure will be.
Okay. So we'll more than likely not convening on the 24th. Thank you, John. Any other questions?
I had one.
Yes, Rachel.
In the solicitor's rules number 3, it states about the solicitor's duty to the court and the administration of justice is paramount of inconsistency with any other duty. What does that mean?
If there's a duty to the client and a duty to the court, then the duty to the court must prevail. Let's take an example. You're prosecuting a case on behalf of the client, and as part of your preparation, you do some research, you find 2 cases which are directly on point. One case is in your client's favour, the other case is against you. In your client's interests, you would simply raise the case that's for you, and you wouldn't make any reference to the other case. But if you did that, you're not assisting the court by presenting the law as it should be presented. So let's say the case which is good for you was overturned by a later case in the appeal tribunal. You have a duty to the court not to go in and just advance the first case without telling the court about the other case. Does that make sense?
Yes, yeah.
Thank you, Rachel. So that's an example of how your duty to the court is paramount.
I have a question, actually, a follow-up on Rachel's question. If a case has been overturned by a higher court, does that mean that the statutory interpretations that existed in that case, that we should not take them into consideration in the case that we're dealing with?
Yes. If the first case was overturned by a superior court, then essentially the law is now as per the decision of the superior court, and the law is not as per the decision of the first court. Thank you. All right, well, we might wrap up soon, but if I could just go around to check if anyone has any questions. Carla, do you have any further questions? Thank you. Jackie?
No, right, thanks.
Rachel?
I'm fine.
Okay, thank you. John, any questions or comments?
I think we've covered everything. Thanks, John.
Thank you, John. Shelley, sorry I haven't said hello to you yet. Any questions or comments?
The document that you were going to look at next week, I just didn't hear what it was.
No, what was that, sorry? Oh, the document for next week?
Yeah, what was it?
Okay. It's on Moodle, and it's Court Etiquette, 50 Tips on How to Behave in and for the Courtroom. It's presented by Dean Morzone, QC, and it looks like that.
Okay, it's on Moodle. No worries, thank you.
It's a Word document. It's on Moodle at week 6.
Okay, thanks.
Andrew, any questions or comments?
No, I'm good, thank you.
Okay, thank you very much. All right, well, look, thank you very much for your participation. We might wrap it up, and hopefully we can talk to you next week. In the meantime, Make sure you get your second assignment in by 5 p.m. on Friday, if you haven't already. And please raise any questions through Moodle or send me an email at johnmilburn@milburns.com.au. All right, thank you very much. We'll end the recording now.
Thanks, Jenny.
Thank you.